Okay, good afternoon. This is Gregory Giagnocavo. I'm going to present to you today an overview, basics about filing a trademark, and the considerations that you want to look at, mostly from a business strategy point of view. I'm writing a book called File Your Own Trademark. You can see it there. And that book will be out shortly, and that's going to have lots and lots of information, very detailed information, whereas this webinar, this presentation is more or less like an overview. And this overview is more like a business strategy as opposed to like the legal nitpicking and all the legal considerations. I'm going to talk about it in general. So in business strategy webinars, I'll read from the screen here, can be easy and clear cut. So you actually can file a trademark by yourself. However, they can easily become complex and problematic if you were to ever run into problems in the future, or if the trademark you're looking to trademark right now has some similar sounding other variations out there, and you're not really sure if you can get your trademark through or not. Remember, all the fees that you pay to get a trademark when you file, they are non-refundable. So sometimes it's worth it to have a lawyer work with you on just even figuring out if what you're looking for is going to be trademarkable. So filling out the application is a little bit complex, and even getting a trademark can be easy, but defending it later on, litigation can be costly. You may lose, and that could actually, losing a trademark lawsuit is nasty. You can lose you can lose and be required to either change your name or some of your colors. You have to destroy your labels and printed materials, and even in some cases they'll make you destroy your inventory that you have if it infringes on the trademark. So this is a general overview for business strategy. Laws do vary by jurisdiction, but general strategy that I'm going to cover does not vary much or at all. So you might be greatly benefited by working with a trademark lawyer. Be careful though, not all lawyers are proficient in trademarks or what is called IP law. So the difference between trademarks, copyrights, and patents. Well, all are forms of legal protection in the area called intellectual property or IP law. And a trademark, which we're talking about today, protects you from others using a similar name or mark. So a mark is something you trademark, and in trademark law they call it a mark, but we'll call it trademark. Now, copyright pertains to original creative work such as art, music, literature, even computer programming, something that you create by yourself, that's creative. A patent protects inventions, new ways of doing things that are non-obvious. So if you tied a rope to a tree and then tied the other rope to a cow, you couldn't really patent that rope unless you had some sort of a specially invented clasp on the one end that if you pressed it one way it opened and it pressed it the other way it didn't. I didn't file a patent for that. What is a trademark? Well, basically speaking, a trademark is a registration of something that you use to distinguish what you're doing from what others are doing. For example, ones that you easily recognize, a design or an image, such as McDonald's arches, they're recognized around the world. A phrase or a slogan or a tagline. For example, Snap, Crackle, Pop, Rice Krispies, they even made a jingle out of it. So that jingle would even be, or could have been, trademarked, just the music alone. Sounds or music can be trademarked as well if it's in conjunction with the business of the business that you're doing. For example, T-Mobile has a specific ring. NBC, bong, 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 they have unique sounds that they've trademarked. So you couldn't use that in the same field or the same class. Now, if you were doing cat food, you could probably use the T-Mobile ring or the NBC tone or other music. And as long as people aren't confused, that's the main thing, is that you can't confuse other people and kind of ride piggyback on someone else's goodwill. You can trademark drawings, like that Johnny Walker guy, and even that phrase, keep walking, I'm sure is trademarked as a slogan or a tagline. And then you can have words or combination of words. Now, what are called dictionary words are normal, regular words. Although, every year they add new weird words to it. Basically, it's a dictionary word that's a common word. Or you can make them up. So you can combine words and come up with something new that you might be able to get trademarked. Or you can make them up. Or you can do a variation by changing the spelling. For example, here, Krispy Kreme. Those are not generally recognized dictionary words. And so a trademark uniquely represents a product or a service, and the purpose is to avoid confusion in the mind of consumer. So if you keep that at the top of mind, then you'll realize that you might think you're doing something tricky, but if it's still confusing to someone else, then you won't get the trademark. Or if you did manage to be able to get it, you're not going to have an easy time litigating it, protecting it later on. So the basic idea is to prevent someone from capitalizing on the goodwill of others. If you want to start a hamburger place and put the arches on it like McDonald's has, you're not going to be successful. You get sued by that. They're going to tell you that you're riding on their goodwill, on their trademark. Now you'd say, well, I'm not going to do hamburgers. How about if I did a kid's crayon box and I put the McDonald's arches on it? You're going to find out that you can't get away with that either because it's too similar to something that's so well known. There's a lot of subjective analysis that goes into this. It's so well known that anyone would assume that McDonald's is related to it. So things take on a meaning after a while when they become so well known you can't even use it. Like couldn't think of an example where you could use McDonald's arches or something that was so close that would look like McDonald's. You're just trying to trademark on their goodwill is what they would say. Now the benefits of a registered trademark. Well, by using your mark, even in local commerce, you do have limited trademark rights. But those limited trademark rights are very difficult to pursue infringement by others or to protect them when someone litigates against you. And it's limited to one kind of business or a class and to the local area. For example, Burger King. When Burger King, the big company, got started and wanted to franchise, and they did an exhaustive search, they found out that someone in the United States, in the southern states, had been using, a husband and wife, had a restaurant called Burger King, and they sold burgers. And so it became an issue. Now, the little guys couldn't possibly face litigation and win, but they did push back, and what Burger King would have had to do is allow them to use Burger King in their local area and in 50 miles out, or not even maybe use in that state, and they just didn't want the hassle, so they made an agreement that the Burger King, they licensed actually the name back to them, so the people with the original Burger King were allowed to continue in that area, that defined area where they could operate. And I can't remember if it was just for a number of years but they kind of negotiated something and settled something. I actually have my own stories. ABC sued us when we were in publishing. We had a name called Classroom Connect, and we had everything printed up. We had gone to trade shows. We sent out tens of thousands of these newsletters for several months. People really knew us, and we invested a lot of money in this. And then we get this letter saying you have to stop using the name Classroom Connect because ABC has a trademark on Classroom Connect, and wouldn't you know it, it was called the Connected Classroom, which generally speaking would be too close for us to use. However, when we dived into it, I mean, at first it makes you sweat thinking, how's a little company going to go against ABC? But we dived into it and found out that they were the Connected Classroom, and they had filed only for a certain way of using that with classrooms, and it was for television and programs. And so we didn't do any of that, and we were only doing printed materials, and basically going back and forth. ABC kind of backed off when they let us. They figured we were a small company perhaps, and they never really pursued it. Another one was there's an office building on the right-hand side there. I built that office building with some partners, and beautiful office building. And as we're getting it up and put the sign on, just put a $10,000 sign on the side, we get a letter from the people that own the residential place next door, a huge company owned by Alcoa, billion-dollar company. And they're telling us we cannot name the building Weston Office Building because they own the trademark to it. But we were on Weston Road, and that area generally became known as Weston anyway. Well, again, digging in their trademark, it turns out they had slipped up and they had only put down for residential dwellings and multifamily dwellings. Nothing to do with office buildings or commercial or stores. And so we were able to win that without even going to court because they had not taken enough time. They could have easily done it to begin with, to put office building and commercial stores and so on, parking lot, whatever, but they didn't. They only did it for residential. So we'll get into classes in a little bit, but the class, or what you're trademarking for, like are you doing children's clothes, are you doing industrial tools, or are you doing furniture, those classes are really important to decide which ones you're going for. Now, it's going to, with a registered trademark, it's going to allow you to expand your company and protect your IP assets along all the way. For example, licensing, protecting against knockoffs. You can advise customs and they will halt the knockoffs coming into the country. So you can assert your right that if you had something called Vinkley I'll make up a name, called Vinkley, and you were importing these little toys, and someone else wanted to use the same name or with a slightly different spelling, something that would cause confusion and writing on the back of all the work you did, well, you could tell customs that you have the trademark, show it to them, and they would then, as they're going through things, if they see any knockoffs, they'll halt them and seize those knockoffs. You can try that yourself. You can try to import something very popular in the United States, make some fakes, try to bring them in, and you're going to have a more than 60% chance you're not going to get them through. Now, when you're registered, you can actually use a little R with a circle around it, which means federally registered. In the States and Canada, you can only use TM if you're claiming the trademark. You can use that trademark, you're claiming it, but you can't use the R unless you're federally registered. That's actually illegal. When you use the TM, it puts people on notice that you're pursuing a trademark or that you're claiming a trademark. Doesn't provide you a lot of protection if there's a lawsuit, but it's a good thing to do when you start out before you have your other trademark. So it's best to file as soon as you start your business to get the best protection for your trademark. Now, is a trademark necessary? I'm generally thinking it is necessary. I think you should. But there's times when it may not be necessary. For example, if you're a small business and you're only doing business in one geographic area, let's say that you are sewing, a tailor, and you're only sewing and fixing clothes. Maybe you just have a used clothing thing. Maybe you have a muffler shop. And really your desire is only to run your Dave's Muffler Shop in that area. And you're just happy to be that way. And you have no plans for big expansion or going to other areas. So it's unlikely someone would use your name in the same local area. And besides, you would have trademark protection in that area. In fact, I would say that even if you are just Dave's Muffler Shop, spend the $25 or $80 depending on your state in the United States or your province in Canada. And file a local trademark. It's a very small thing. You file a trade name, and it's called a fictitious name or doing business as, and you'll get a little bit better protection and put people on notice that you were the one using that name in that area. So if you don't have plans to expand outside the area, I don't know how you would really know, though. I wouldn't take the chance. But if you're really sure you're not going to, or if the local business is in your name, like Kathy Williams Real Estate, you can trademark that, but you wouldn't have to if you're only doing it in that area. Now, when is it really necessary? Really for most businesses, to protect your name and your product names and to sell for the highest amount or obtain investment. I know if I'm investing in a company, I would always want to know that they have everything trademarked. I'd want to know they have patents filed, copyrights. I'd really want to know that they've got all that protected because that's part of what you're selling. When you're selling a company, you're selling your goodwill, you're selling your brand name, you're telling a story about how great you're going to be, but you've got to have that stuff protected. The investor doesn't want to have to do his own digging and then find out you can use the trademark here, but you can't do business there, and so on and so forth. So you really ought to have that up front. And you won't get as much for your company if you don't have trademarks. And if you're going to license it or franchise it, a lot of times you don't know it first, but then you definitely want to have a trademark or you don't have anything to license and franchise. The danger is that if you don't do this right away, people in other states or other areas will say, that's a really neat name. That's a neat company. Look at all the cool things they're doing. Ooh, they're not trademarked. And then they file a trademark. And in some areas, you don't even have to be making a product to file a trademark. In other areas, you have to be in commerce to file a trademark, to obtain a trademark. But really, if someone beats you to it, and you've already been doing it for years, now you find out that you can't franchise in 3 states out of the United States or some provinces or some countries. Now you're really you're in hot water here because you've got to decide, is it worth fighting in these areas? Do we skip those areas? Diminishes the value of your company. Now, there's some differences between the USA, Canada, and the EU. And, of course, there's lots of other countries, 200 some countries. Many of them, I think about 119 countries are part of something called the Madrid Protocol. If you're in Europe, that might make a difference on how you file. My personal opinion is you should always file in the country of your citizenship first if you're in the EU. And that way you don't have to contend with all the other EU countries objecting to your trademark. Get it in your one country, and once you have that, it gives you a leg up in going forward. And it does give you trademark protection. In the US and Canada and the EU, you can file before you start your business. You get limited protection even without filling out a trademark application, as I mentioned, in local geographic areas, just the fact that you used it. And the USA and Canada, you can receive protection only if it's in use, if you're using it, or if you're intent to use it within the short term. I believe it's within 6 months you have to prove that you're using it. And that's the people don't squat, as they call it. They call it cyber squatting for domain names. And the same thing here. Otherwise, someone's kind of quick will go ahead and quick of mind will say, oh, they'll come up with a whole bunch of names, just file them, and you can do this in Europe. You can file a name and have no intention of actually doing anything and see if you can sell it off. Great idea. Trademark, sit back, maybe even advertise it, and sell it to the highest bidder. But in USA and Canada, you have to have a use for it right away or intent to use it. If you do file an intent to use, you have to later prove that you actually used it. You have to submit proof to them within the time period. In the EU, the mark can be registered to get protections called first to file. Doesn't matter if you have a product or using it right now. Trademark must then be used within 5 years, or someone else can object and say, hey, these people have the trademark that I'd like. They haven't been using it, so they either need to be using it or they can cancel a trademark for them and they'll give it to the next person. So it's best to file in the country of citizenship first and then the EU to avoid more chances of rejection. That's a strategy I would use if I was a small business person, entrepreneur in the EU. Now, choosing a trademark, this is really tricky because we're going to assume that you don't have one right now, but you got to put some thought into it. And even if you have one, you may have something that's either too generic sounding, or maybe even conflicts with somebody else out there, and you want to get a trademark, you can get one that's close. That might give you good protection. But you have to choose it carefully. So small differences can make all the difference. So let's say a strong trademark would be something that was invented words or spelling, like the company Flickr, which was sold to Yahoo. I know that guy actually that invented it. And something that's not descriptive of the product or services, like say Pringles. Pringles doesn't tell you exactly what it is. If you've heard the ads, you know that it's these curved and fluted, special shaped chips. And then something that's obviously unique. So when you make up a name for something and a special spelling, that's a strong trademark. Now, weak ones would be regular words or something that actually describes a product. Now, you might think for marketing that a name should describe the product. So if the product's in the name, you're like, oh, like I'm even thinking of like chapstick, for example. You can kind of figure that out. Or it might be a super glue that describes a product. You've got to be careful with those because if they're using regular words like, I don't know why you'd want something called fresh meat, but if you called it fresh meat, even shredded wheat. Now, most of us think that shredded wheat's a trademark, and they do use it as a trademark name, but it's not a trademark because it's two regular words. And when they went to patent it, this is like, I think in 1901 or 1898, the company, National Biscuit Company, and Nabisco actually, they described a way to shred wheat and make it into these little puffy shapes. And then when they went to use it as a name, they found out that Kellogg got the idea like, hey, I'm going to have shredded wheat now as the name of the product. Then they fought back and forth, and the court said, you know what, it's two regular words. Shredded wheat is a thing. There's a patent on it as a thing, so it's not unique enough to trademark it. And they lost the ability to trademark the name. Hasn't stopped companies from using it over the years, of course, but that would be disappointing if you had a company for a while and thought you would be able to trademark something that you can't trademark. So suggestive words are suggesting what the product does, such as veggie blend. I think you could probably figure that out. Or Loctite glue. Now, those are spelled oddly, so it's unlikely that someone else has a spelling like those when they went to trademark them, but it also hints a little bit at what the product does. So if something is really, really descriptive of the product itself, that's actually less likely to be trademarked, even though you might like it better for marketing. And a compound trademark is a combination of words or even words that make new words, such as iPhone. You have the letter I and plus the word phone, but together they make something new, even though those are two regular letters. And when you, I think I covered this later on, but when you go to trademark something, you have to say you're not trademarking the actual word. You have to do what's called disavow. So when they went to trademark iPhone, they had to say, we're claiming it for iPhone as a word put together, but we're not claiming that we own the word phone, and we're not claiming that we own the word I. So choosing a trademark, so you really need to do your own trademark first. Don't just think it's cute and all your friends think it's a cute name. You've never heard anybody else use it. Well, the internet's a big place. The world's a big place. So Google the name ideas that you have and make sure do thorough Googling, thorough searching. You can even search certain states. There's different databases. I noticed I mentioned them here for Canada, the US, and Europe. And you need to spend some time on this. This is why lawyers charge hundreds of dollars to do a trademark search because you need to look in all the nooks and crannies of the internet and the world to see if anybody's using it. And don't get too smart. Just because someone has a letter that's a little bit different or slightly different category, don't assume automatically that you'll be able to get the trademark. And remember, these fees, which are $285 to $500 depending on where you're filing, they're non-refundable. So search high and low, look for anything similar. When you find a name and you're disappointed at first, then I would also say don't give up. Because if it's only for, let's say, office equipment, and you're making children's toys, you might still be able to use it. But it is best to avoid anything that looks or sounds similar. It'll be less work later on, less risk later on. There's the databases there for the USA, Canada, and EU to check. And of course you can Google for different databases. There's a company I really like called Marcaria.com. It's a private company. They offer a service to handle your trademarks for you. You have to do a lot of the work yourself, but it's better than doing it just by yourself. And they service 200 countries. They do thousands and thousands of trademarks. I like them a lot. And they offer you free searches for each country. It's really handy. Now, you'll need to, is what I was mentioning, you'll need to disavow plain English words. So if you wanted to have super rinse, I don't know what that's for, maybe it's for a car wash, you need to make it clear. You have to tell them, I'm not claiming the word super and I'm not claiming the word rinse. Now, if you didn't know about disavowing, you would submit super rinse. You'd think you're smart. You'd pay the few $100s. You would wait and you would get a rejection saying you can't trademark super rinse because super is a word and rinse is a word. And by the way, you didn't disavow them. If you'd like to pursue this, please submit another few $100s in a new application and make it clear that you aren't claiming the word super or rinse. So there you would have waste 3 or 4 months and hundreds of dollars with an attorney or filing fees. Your attorney would, I'm sure, catch that. So the best and easiest, try to come up with something that is a unique spelling, like Krispy Kreme. Here's one that's popular, at least in the States. Snap, crack. The song was Snap, Crackle, Pop, Rice Krispies. Now, what they did was they did a drawing with the words. I'm going to show you. So when you could have a drawing with the words, that you might not get the words alone trademark, you put a drawing with it, and then you get it trademarked because it's a unique combination. And then from then on, people can't just use the words. Like you can't use the words Snap, Crackle, Pop, Rice Krispies for a cereal, even though you don't have the drawing, but their trademark includes a drawing. Remember, humans will review your application and check your claims, such as your website, your email. If you're using it in commerce, you have to be careful and you have to be consistent with whatever you tell the trademark office. You need to have visible when they do their check. They're actually going to use Google. They're going to go to your website. They're going to look and see when your website was registered, right? Like they're going to look up in the databases. So you can't sneak much by these guys. So here's the actual Snap, Crackle, Pop drawing plus words. So they have the little characters, and the characters are called Snap, Crackle, and Pop. You can't see it here too clearly, but on their hats were the names. And so they even said here, they didn't claim color because you can actually trademark color, the use of color with your word, with your mark. And now they describe the mark, and they describe it as 3 elf characters with the word snap on the hat, the word crackle on the hat, and the word pop on the 3rd elf character's hat. They say it's for cereal, breakfast foods. And then the international classification covered mustard, vinegar, sauces, coffee, tea, cocoa. So you couldn't have Snap, Crackle, Pop cereal and then say, oh, I'm only going to do powdered coffee because they've already claimed that it covers that. U.S. Class Code 46, if you look that up, you'll find it was recently deleted. There's only 45 now. Well, here's one I did. This is one of my trademarks. And here's something different. We went and said it's a word mark, but we put a drawing with it, so no one could actually. So this actually trademarks the drawing. I even put in for colors, and the word connexion. Together, that's our trademark. But you couldn't use that globe in our class, and you couldn't use that name without the globe in our class. In this case, it was telecom. And I even snuck down in there notification alerts via the internet notifying individuals of E911 calls, because that's something we did. And we have fax and SMS in there. We put a lot of it, toll-free, mnemonic telephone numbers is one thing I put in there. And that's if you want to sell numbers, we provide numbers that might spell like 1-800-FLOWERS. It's a word and it's some numbers. So I tried to cover everything, including prepaid calling cards. And then down there you see the description of mark. The colors white, black, orange, blue, and purple are claimed as a feature of the mark. So if someone wanted to use that, and maybe you want to use it in called Teleco, but you want to use that globe with those colors, we could come after you if you were in our goods and services classification. So it actually gets more complicated than that when you have something called Tiffany Blue. I'm going to cover that. When you trademark colors, you can actually trademark a color like Tiffany did for the Tiffany Blue box. You can't sell jewelry, or I should say, they can claim you're infringing upon them if you're trying to sell jewelry in that exact color of box, if you mimic their boxes. Doesn't seem to stop people, though. I go to markets all the time with that stuff there. Now, choosing a class. So now you maybe come up with a name that you're really excited about, and you've searched pretty well, and you're pretty sure nobody else is using it. Trademarks are registered by categories or classes, and that is what you're doing with it. Are you making children's furniture? Are you making children's toys? Are you making breakfast cereal? Are you making car parts? Makes a difference. There's 34 classes for products, 11 different ones for services. And classes have numerical codes, and there are standard international classes, and you can look this up too. Each class after the first one costs extra money, may or may not be necessary, but think very carefully. You might as well fork over the extra few $100s to add extra classes like we did on the one I showed you on Connexion. We put a whole bunch of stuff together. So you want to think that carefully, because it's going to be a problem if you decide that you're making children's toys and now you want to make baby blankets and maybe it wasn't covered. That's an example I'm not sure about, but that may not be covered. You might as well pay the extra to put in baby clothes or blankets or toys or something that's separate from the baby furniture maybe that you first filed for. It's much less expensive to pay the fee for additional classes now than litigate later. And these classes have subclasses, so you can tell exactly what it is that it covers and what you're claiming for. So for example, here is one. Classes or categories. Number 005 was beds. You might say, oh, beds, how hard can that be? It's pretty interesting. Look over, click on that, and then it expands it, and it says, here's the subcategories, the miscellaneous other articles. So is it a bed? I look down, there's one called, where's that over here? Bed stored in ceiling. Don't know about that one, never saw one, but apparently that's something else you can cover. Knockdown sofa bed, beds stowed under a seat, vertical unfolding beds. They rotate, they have sides, they don't have sides. They're folding out from a sofa. All these different things. You need to pay some attention. If you're confused about it, this is where you really ought to have a trademark lawyer work with you on it. Trademarks, they vary depending on the jurisdiction, how long they're for. And it's unfortunate that some people, I guess, let them lapse. Either they didn't pay attention. If you do a search for trademarks, you'll see a lot of them they're lapsed. They weren't renewed. And then you can take them usually. Not always, but usually if something's been as lapsed and it's not in effect anymore, you can take that trademark. Depends, of course, if they're still enforcing it locally, if they're still in business, but gives you a leg up on it anyway. In the USA, it's 10 years, but you have to file a proof of use between year 4 and year 5. Don't miss that, or your 10 years won't be valid. Central American countries, many are only 5 years. Europe and Canada, generally 10 years. I say generally because there are sometimes the proof of use. Like we mentioned in Europe, after 5 years, if you aren't really using it, someone else could claim. The trademark office won't cancel it, but someone else could claim you're not using it, you're just hogging it, sitting on it. So it's critically important. Here's something that's not mentioned sometimes, but it's critically important that you maintain a valid postal, email, and phone number with the trademark office. Doesn't mean you can't change it, but you need to keep them aware of it, because they could put you at risk of losing your trademark. Maybe there's a renewal date, renewal due, fees are due, or someone's claiming something and they can't reach you, and they want to claim that you're infringing, or they are going to make an objection to the trademark office. And if they can't really reach you, they can still advise the trademark office. The trademark office can't reach you. They'll give you a certain amount of time. They can publish it in certain legal publications. You're not going to know how to figure that out or notice it. And if you're not, especially if you don't have a lawyer. So it's pretty nice to have a lawyer. That's one of the reasons people like having attorneys, is that they're responsible to get all the notices. Hello there, Miss Carbonell. Nice to see you. I'm recording this, so there'll be a recording I'll be posting today, later on. Claiming use in commerce. Generally, it's better to claim that you're using the trademark that you're seeking. Now, you can claim, as I mentioned earlier, about intent to use. I don't do that because too many things can go bump in the night and cause a problem, and so I don't do that. So what I do is I always claim I'm using the trademark, and here's how you do that. Examiners are going to do the research to see if you actually deserve the trademark, if you really qualify. For example, if you say they're using it in commerce and they don't see any effort of that, they don't see any evidence, they're going to deny it or ask for further proof. It's going to cost you a delay in time and money. So what I do is this: if I'm applying for a trademark, even if I don't have I kind of hijacked somebody else's trademark from a really big company because they had let it lapse. So I did all these things. A website. You create a website, even if it's on a free service, and this shows that you're using the mark in commerce. So what you do is you offer a trade, you offer a service, or you offer a product for sale on this free website. And you have proper contact information for yourself in there, an address, a phone number, and an email address that matches the domain of the website. So that looks very much on its surface, it looks very much like you're using it. The domain name, use a domain name that's very similar to the trademark you're claiming. And use this for your website and your email on that website. You might want to make it look like you're really using this in commerce. And this isn't totally fake. I mean, you want to use it in commerce anyway, but if you haven't really got your act going, you want to put all the evidence you can out there so that the examiners can see it. Press releases. Publish a minimum of 5 press releases as early as the date you claim to be using the mark, and space them apart. Use different press release services, and many of them are free online. Sometimes you have to pay a little bit. I wouldn't mind paying up to $80 to really get it distributed. Then it's going to be in Google News, it's going to be on Yahoo, it's going to be on the big sites. And utilize services even on Fiverr that'll post to blog sites. I mean, just make sure they're relevant sites. And now these guys will post to hundreds of different blog sites. And that way, when you do a search, you get a full page of results on your company coming back. Social media, of course, it's really important. You, as a separate topic, you want to create accounts on all social media channels using your trademark name and try to have the same one for everything. If you can't get the same one for everything, modify it slightly, use an abbreviation, add a digit or another letter or a couple letters. Make it so that people should be able to find you. It's difficult, of course, more and more with billions online, but they should be able to find you on every different channel using the same name or almost the same name. So what you want to do is create accounts on these channels, use the name that you're applying for a trademark as close as you can get. And then when the trademark examiner does their examination, these humans, they're going to find you all over the place, and that's what you want. So give the trademark examiner a clear reason to believe that you're actually using the trademark in commerce. When you're very, very visible, it makes it easier for them, helps you defend against objections. Now, what do you want to trademark? We talk about your name all the time. Sure, you want to trademark your name, but there's other things too. For example, I put here Marco Polo e-commerce coach. If my name was Marco Polo and I was an e-commerce coach, those are pretty standard names, e-commerce and coach. I'd have to probably disavow them. I think e-commerce is now in the dictionary. But you could get a trademark for that. Now, because it's your own name, you really don't need a trademark. But if you really wanted to make sure in different countries and really enforce it, I would probably do that. Now, you need permission if you want a trademark for a living person, even if it's your mom or your relative. So you just have to get something signed by them. It's not that difficult. You can use a deceased person's name, like a president that died or somebody famous that died, if there's no confusion. So if Vidal Sassoon dies, you can't immediately start using it to make shampoo. And that was a pretty ubiquitous name, so I don't know what's out there. You couldn't use it for fashion items either, but if somebody famous died, you could use that name if it didn't cause any confusion. Now, the thing about famous people is their name's used a lot, and so it's a little bit difficult to do that. But that's the law anyway. So you'd trademark your business name or your brand name. Phrases or slogans, just like De Beers did. A diamond is forever. They trademarked that. Hershey's has melts in your mouth, not in your hands. Thousands of them. Logo, design, or a drawing. You can even trademark specific colors, like I mentioned, the Tiffany Blue. Now, these colors actually have numbers ascribed to them. So they use the Pantone color wheel. And there's thousands and thousands of numbers that have a formula associated with them. And Pantone is one of the ones that's actually recognized as an official source. So you'd say I'm using Pantone 6321 brown or burnt brown, whatever they call it. And that would be a color you could associate with your brand so tightly that you could actually get a trademark. Now, having said that, that also requires you to use it all the time. You can't use 6 different kinds of color and then claim that one of those is the one you use all the time. Tiffany never uses anything but Tiffany Blue. And then trademarking a combination of words and a drawing together, like we talked about Snap, Crackle, Pop. someone I know is, let's say you were trying to do the branding king. And the branding king, those are normal words, and they might not want to give it to you, or they give you a hard time about it. I would put a crown with it, or a drawing of a king, a little cartoon drawing, and I would put that together and say that I'm trademarking the mark, the drawing, and the words together is my trademark. When you do that, nobody else can use the branding king without the drawing anyway, because you've trademarked that. It's too close to what you're already doing. I always want to trademark the name separately from the logo, but that's one thing you want to do is do them together as well. Now, internet domain names, not talked about very much. Very few trademarks on internet domain names, but it's very important to not have it hijacked from you. In the case of litigation, a lot of these companies, and I made a post about this, I'll post it in the trademark group here. Some companies are more willing to just give the government all the information they need about the owner and actually suspend the use, like freeze your domain name because they have government contracts. They're real cozy. Other countries you can register you can register .com in many countries, and I would use a registrar that was not in the United States. I don't trust the United States registrars. They fold too easily for litigation purposes. But when you, let's suppose that you had something called the Big Fat Branding King, and you had a domain called bigfatbrandingking.com, and you trademarked your, you went to go get a trademark. And while you're doing this, someone else makes a claim that it's too close to the branding king that they trademarked, maybe in Europe, if you're not in Europe, in some place you weren't familiar with it, you didn't know about it. And it's really close. So, but if you have your brand name, it gives you a much, when you're trademarking your brand name, if you have a domain name already trademarked, it gives you a much bigger leg up. And trademarking domain names is much easier, much quicker than trademarking a regular name. I do both of them. You want to do them all the time, and that freeze frames your rights to the domain name, the .com part, and it's a very good way to totally, the first thing you're going to be asked, if someone's investing a lot of money in your company, they want to know what you trademarked, and I'd want to be able to say, we even trademarked our domain name in 4 different countries that we deal in. That really makes them think you're smart, and it's something they want to see. You can trademark telephone numbers. 1-800-FLOWERS, that's a mnemonic one. That's trademarked. 967-1111, they made a song out of 967-1111. I remember that, I haven't heard it for 20 years. And that's a pizza place in Toronto. So you can trademark colors, you can trademark sounds, phrases, slogans, anything that sets you apart from somebody else, you can trademark that. And the interesting thing about copyrights protect your original creation, like a drawing. So you can actually copyright, like that Snap, Crackle, Pop, or a crown or a little character you did for the branding king. You could actually copyright just that thing that you drew, that little logo, that little cartoon. And you could trademark, you could copyright that. And now you'd have copyright protection as well as trademark protection when it's used in conjunction with the words. Now, defending your trademark. If you're growing a lot, if you're in an active space, this is something you may run across sooner rather than later, and you're not going to like it no matter when you're going to get it. 2 parts of defending your trademark. One is on the offense, and that's this one. You must defend your trademark to keep from losing it or losing its effectiveness or relevance. You can keep using your trademark and then find out later it's become such in common use that you can't renew it. It's not worth it anymore. They don't allow you, or it's degenerated. It's become watered down. For example, Kleenex. Most people don't say, do you have a capital K Kleenex? They just mean tissue. Can you Xerox this? Can you photocopy this? Can you make me a Xerox? Do you have a Xerox machine? It might not be Xerox brand name, but people kind of associate that with photocopy. And it became so, it's almost against their own good. They became so popular that they became irrelevant as far as their name. Now, they still maintain the trademark, of course, but it loses its effectiveness. Now, if you see others using your trademark, if you want to defend your trademark, you must advise them to stop. So when you send out a cease and desist letter, when you advise other people, stop using your name because it's too close to mine, or you're using mine, there's 2 parts to that. One, you want them to stop. You want to threaten them. You may want to litigate with them. But you want to have a record of showing that you regularly defend your trademark. Sort of later on, it's said that your trademark has become public domain, and it's not really trademarkable again. You want to say, hey, I've been fighting people left and right. There's just a whole lot of them. And you want to be able to show that you've had a lawyer, you've been sending out letters, and that you've litigated maybe once in a while. Now, on the other side, if you You may need to defend against other people coming after you, claims of infringement or unfair use or too close. But don't panic if you receive a cease and desist letter. It's the first warning, the first shot across the bow, and it isn't final, but it does put you on notice. So you need to pay attention to it. Now, when it's interesting, you're doing business around the world, many of you are, and some of nomad lifestyle, and you're not really anywhere at any one time. You're doing business everywhere, but not any one place particularly. And this is where it gets a little bit fuzzy. When someone says to you, and they write from let's say they write from New York, and you're in Thailand, and they say, hey, you're using our trademark. Well, they're in New York and you're in Thailand. It's unlikely they're going to be able to sue you in Thailand, or they're going to follow through on it, unless you use the exact same name and they're a big company and you're doing exactly the same thing as you are. So if you were selling chapstick and you try to start that up in another country where they didn't maybe have it already registered, yeah, they're going to fight you for it. So the thing is, they can't enforce it very easily if they're not a really huge company. And if you're not really, you need to take a look at you almost have a really close look at the cease and desist letter, because just because you got a letter doesn't mean they're right. It just means they shot that letter off because, as I said, it's one of their ways of protecting their mark. And also, they might want you to stop, but it may be that you were using it before they were. Or it may be that they think you're making chocolate candy and you're only making children's toys. So you have to really look at the classes. You need to get a lawyer involved in this. What you do not want to do not pick up the phone and call these people. Do not answer them by email to another lawyer. Only your lawyer should do that, because they can trick you into saying stuff, admitting things. You might say the wrong thing and it'll get you deeper. Just ignore it personally and give it to a lawyer. Don't write back. You're not going to be able to negotiate anything with these people. They're out to put you out of business and to shut you down from using it. And don't think that you're so cute you can get away with it. So you need to take that seriously, but actually use a lawyer and slice and dice it and see why they're claiming what they're claiming. Defending is necessary. You could lose your rights to your valuable name. You might be required to destroy materials, give up your social media accounts, your domain names, and destroy inventory. It's much more involved than we're going to cover right here, but when you get a cease and desist letter, that starts the process of other people thinking that you're in the wrong and the guy who sent the letter is right. And if you don't respond, or they don't like you respond, they could actually file a lawsuit. Then they notify the domain name registrar that they're using the name illegally and they want all the information on you. Then they're going to find out whether you're in the U.S. and they can serve you then in the U.S. So you want to be really careful about what you put down as your address for your domain name. And these large companies, some of the largest in the United States, they're very, very easy pushovers. And they can get a demand letter, cease and desist, a demand letter. They could even possibly get a court, a temporary injunction against you using the domain name, and immediately all your internet traffic stops, all your email. Imagine what that would do to your company if somehow you got your domain name suspended. So you need to have several domain names, and you need to be able to reach all your people by email to tell them that you have trouble and here's your new domain name. But one of the ways you do this is you trademark your domain name. You don't register your .coms in the USA, if that's where you think the threat's going to be from. And answer these cease and desist letters, but have a lawyer do it. So I'm sure you have lots of questions. If you don't, that's fabulous. If you want to just go straight to a lawyer, that's a good thing to do. I started a Facebook group called File Your Trademark with an exclamation point. It's easy to find. I'm easy to find online under my name. I have a profile on Facebook. And there's lots of good online resources for general information and ideas. Don't think you're going to litigate anything because you read something on the internet. That's dangerous. One thing you can use the internet for is to find a good trademark lawyer. I may be able to suggest a trademark attorney or a service for you. Attorneys are best for legal advice, not necessarily strategic advice, because just the time that you spend with someone who knows about trademarks for business strategy could save you hundreds and hundreds of dollars. Even the few things we covered in this trademark could save you hundreds and hundreds of dollars, because the lawyers aren't really into the strategy. They're just supposed to protect you based on the law. Some lawyers are better than others about business strategy, but they're mostly there for the law. I have 30 years experience in business and some personal trademark war stories. I might be able to help you with strategies and ideas, so you're welcome to reach out to me. Thank you for joining today, and there'll be a follow-on from this webinar as well. We'll have another one soon. Thanks very much.